good evening. Or, if you're currently experiencing an eerie rattling of chains, an inexplicable drop in temperature, or an invisible hand rearranging your furniture, then perhaps not such a good evening. You see, in my line of work, I am often called upon to settle legal disputes of an unconventional nature. Which brings us to today's topic: Poltergeist Tenancy rights.
Oh, fantastic. More ghost law, because that went so well last time.
The question before us is simple. If a poltergeist has been haunting a property for an extended period, do they, under the law, have squatters' rights?
Do ghosts squat? I mean, do they even sit? Or is it more of a spooky hover?
Legally irrelevant. Now, under the principles of adverse possession, also known as squatters' rights, an individual who occupies a property for a certain period, without permission, may gain legal ownership. The exact time required varies by jurisdiction, but usually it's between 10 to 12 years.
Right, but how long does death last? Asking for a friend.
Indefinitely, of course.
Oh, well then we definitely have a case here.
Exactly. Now, the key issue is whether a poltergeist can demonstrate continuous and exclusive possession of the property. Many hauntings, as we know, tend to be intermittent, sporadic even. If a ghost only manifests once every full moon, or during particularly dramatic thunderstorms, this weakens their claim.
So what you're saying is, if the ghost isn't haunting full time, it doesn't count?
Precisely. Haunting is a commitment. If you want legal standing, you must be consistently throwing plates and whispering ominously at the stroke of midnight. The law does not reward part-time phantoms.
And if the ghost does meet these conditions?
Then they may be able to claim rightful occupancy. However, there is another legal principle that complicates matters. The fact that ghosts, technically speaking, are deceased and therefore cannot be recognized as legal persons under the law. A minor hurdle, I admit.
Minor hurdle? You telling me this whole thing is a waste of time?
Not necessarily. They may not be considered persons, but they can be considered a nuisance. And that brings us to eviction proceedings. If you wish to remove a ghost from a property, you must issue a formal notice, preferably in writing, though spectral apparitions are not known for their literacy.
Oh, sure. Dear ghost, please stop throwing my furniture at the walls. Love the management. That'll do it.
In cases where written notice fails, one must proceed to more specialist eviction methods. These typically involve holy water, the chanting of Latin phrases, or, if all else fails, a firm talking to by a determined priest.
Or just sell the place and move.
Also a viable option.
So to sum up, ghosts can't legally own a house, but they might technically live there anyway. And if you want them out, you've got to fight them in court or hire an exorcist?
That is correct.
Law is weird.
It certainly is. But without it, where would we be?
Living in haunted houses, apparently.
Indeed. Well, that concludes today's legal briefing. Should you find yourself in a dispute with a spectral squatter, do consult your local ordinances before resorting to salt circles and shouting "Be gone!" at the walls. Good evening.